Hello friend, how are you? I'm advocate Gaurav Kumar Gupta. I'm Chartered Accountant and MBA Finance and PhD holder. My project Derivative Market Future Trend Analysis. आज जो हम BNSS की धारा के सेक्शन 85 को जिक्र कर रहे हैं, अटैचमेंट ऑफ प्रॉपर्टी ऑफ पर्सन एब्सकॉन्डिंग। जो पर्सन एब्सकॉन्डिंग हो गया, जो भाग गया, उसकी प्रॉपर्टी को हम सेक्शन 85 में अटैचमेंट करते हैं। बीएनएसएस की धारा सेक्शन 85 में उसे अटैचमेंट प्रोसेस करते हैं। अटैचमेंट द कोर्ट इशू ए प्रोक्लेमेशन अंडर सेक्शन 84 में फॉर रीजन टू बी रिकॉर्डेड इन राइटिंग। सेक्शन 84 में रीजन टू बी रिकॉर्डेड इनटू राइटिंग को देखते हैं। At any time after the issue of the proclamation, order the attachment of any property, movable or immovable, chal or achal, both belonging to the proclaimed person, provided that where at the time of the issue of the proclamation of the court is satisfied by affidavit, otherwise that the person in relation to whom the proclamation is to be issued is about to dispose of the whole any part of his property, is about to remove the whole any part of his property from the local jurisdictions of the court. Local jurisdictions of the court. It may order the attachment of property simultaneously with the issue of the proclamation. Issue of the proclamations. Such order shall authorize the attachment of any property belonging to such person within the district in which it is made, and it shall authorize the attachment of any property belonging to such person without such district when endorsement by the district magistrate within whose district such property is situated. If the property ordered to be attached is adapted other movable property, the attachment under section shall be made by seizure, by the appointment of a receiver, by an order in writing prohibiting the delivery of such property to the proclaimed person to any on his behalf, by all any two of such method as the court think fit. If the property if the property order to attach is immovable, the attachment under this section shall in the case of land paying revenue to the state government be to the state government be made through the collector of the district in which the land situate, and in all other cases by taking position by the appointment of receiver, by an order in writing prohibiting the payment of rent on delivery of property of the proclaimed person to any one of one his behalf, they all any two of such method as the court think fit. If the property ordered to attach consists of livestock, each of a perishable nature, the court may, if it think is expedient, order immediate sale thereof, that in such case the proceeds of the sale shall abide the order of the court. The power, duty, and liability of receiver appointed under this section shall be the same as those of a receiver appointed under the Code of Civil Procedure, Code 1908. Identification and attachment of property of proclaimed person. Proclaimed person के प्रॉपर्टी का कुर्की और उसका आइडेंटिफिकेशन सेक्शन 86 बीएनएसएस में किया जाता है। क्लेम एंड ऑब्जेक्शन टू अटैचमेंट, कुर्की जब्ती के ऑब्जेक्शंस पर क्लेम करने के लिए सेक्शन 87 जिक्र करता है। इफ एनी क्लेम इज प्रेफर टू ऑब्जेक्शन मेड द अटैचमेंट ऑफ एनी प्रॉपर्टी अटैच अंडर सेक्शन 85। Release, sale and restoration of attachment property. प्रॉपर्टी कुर्की 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 वाली प्रॉपर्टी को रिस्टोरेशन करना, उसे रीसेल करना। फिर से अपील फ्रॉम ऑर्डर रिजेक्टिंग एप्लीकेशन फॉर रिस्टोरेशन ऑफ अटैचमेंट ऑफ प्रॉपर्टी, सेक्शन 89। इशू ऑफ वारंट इन लीव ऑफ इन एडिशनल टू समन, सेक्शन 90 बीएनएसएस जिक्र करता है। ए कोर्ट में इन एनी केस इन विच इज empowered by this संहिता to issue some a summon for the appearance of any person issue after recording if reason in writing. A warrant for this is arrest. Power to take bond, power to take bond or bail bond for appearance. When any person for whose appearance arrest the officer presiding in any court is empowered to issue a summon, a warrant is present in such court, such officer may require such person on execute a bond, बॉन्ड का निष्पादन या बेल बॉन्ड का निष्पादन फॉर हिज appearance in such court, any other court to which the case may be transferred for trial. फिर अरेस्ट ऑन ब्रीच ऑफ बॉन्ड या बेल बॉन्ड ऑफ अपीयरेंस, सेक्शन 92 बीएनएस डील करता है। प्रोविजन ऑफ दिस चैप्टर जनरली एप्लीकेबल इज टू समन एंड वारंट ऑफ arrest. Section 93, the provision of contained in chapters relating to summon and warrant and their issue, service and execution shall so far as may be apply to every summons and every warrant of arrest issue under this Sanhita. Chapter 7, process to compel the production of things, summon to produce document and other things. Section 94 में whenever any court of any officer in charge of a police station consider that the production of any document, electronic communication, including communication device which likely to contain digital evidence, other thing is necessary to desirable for purpose of any investigation, inquiry, trial, other proceeding under this Sanhita by or before such court officer, such court may issue a summons. Such officer may be written order either in physical form or in electronic form. Require the person in whose possession power such document things is believed to be attained and produce it to produce it at the time and place stated in summon order. Any person required under this section merely to produce a document, other things shall be deemed to have compelled with the requisition of case such document or things to produce instead of attending personally to produce the same. Nothing in this shall be deemed. Procedure as to letter. Section 95. Search warrant. Section 96. When search warrant may be issued. Section 96. उसके बाद power to declare certain publication forfeited and the issue search warrant for same. Section 98. Section 99. Application to High Court set aside declaration of forfeiture. Any person, section 99 BNS से बताता है, any person having any interest in any newspaper books or other document in respect of which a declaration of forfeiture has been made under gazette of such declaration apply to High Court to set aside such declaration on the ground that the issue of the newspaper, the blog, the book, other document in respect of which the declaration was made did not contain any such matter as is referred in subsection 1 of subsection 98. Every such applicant shall be where the High Court consist of there or more judge more judge heads and determined by a special bench of the High Court, composed of other judges, and where the High Court consists of less than three judges, such a special bench shall be composed of all the judges of that High Court. On the hearing of any such application, with reference to any newspaper, any copy of such newspaper may be given in evidence in aid of the proof of the nature, tendency of the words, sign, visual representation contained in such newspaper, in respect of which the declaration of for future was made. The High Court shall, if it is not satisfied that the issue of the newspaper, the books, other document in respect of which the application has been made contain any such matter as is referred to in subsection 1 of section 98, set aside the declaration of for future. Where there is a difference of opinion among the judge forming the special bench, the decision shall be accordance with the opinion of the of majority of judges, majority of those judges. सर्च फॉर पर्सन रॉन्गफुली कन्फाइंड, किसी व्यक्ति को आप रॉन्गफुली कन्फाइन करते हैं, सेक्शन 100 ये डिस्कस करता है बीएनएस। सेक्शन 100, इफ एनी डिस्ट्रिक्ट मजिस्ट्रेट, सब डिविजनल मजिस्ट्रेट, डीएम, SDM, and magistrate of the first class has reason to believe that any person is confined under such circumstances that the confinement amount to an offence, he may issue a search warrant, and the person to whom such warrant is directed may search from the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate who shall make such order as in the circumstances of the case seems proper. Power to compel restoration of abducting females. Section 101 जिक्र करता है, upon complaint made on oath of the abduction, unlawful detention of a woman, a female child for any unlawful purpose, a DM, district magistrate, and SDM, subdivision magistrate, and magistrate of the first class may make an order for the immediate restoration of such woman to her liberty, of such female child to her parent, guardian, other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. General provision relating to search, डायरेक्शन पीटीसी सर्च वारंट। सेक्शन 102 बीएनएसएस डिफाइन करता है, पर्सन इन चार्ज ऑफ क्लोज प्लेस टू अलाउ सर्च। सेक्शन 103 बीएनएस, डिस्पोजल ऑफ थिंग्स फाउंड इन सर्च बियॉन्ड जुडिक्शंस। सेक्शन 104 डिस्कस recording of search and seizure through audio video electronic means. Section 105 discuss power of police officer seize certain property. Section 106 discuss BNS attachment for future restoration of property. Attachment कुर्की करना, for future means जब्ती करना, restoration property. Section 107 डील करता है, magistrate may direct search in his presence. Section 108 power to impound document and produce. Section 109 any court may, if think fit, impound any document think produced before it under this sanita. Reciprocal arrangement regarding process. Section 110 where a court in the territories to which this sanita extend thereafter in this section refer as said territories resided. A summons to an accused person, a summons to an accused person, a warrant for the arrest of an accused person, a summon to any person require him and attend and produce, a document other things to produce. A search warrant issued by it shall be served to execute at any place. चैप्टर 8 बताता है reciprocal arrangement for assistance in certain matter and procedure for attachment and forfeiture of property. Definition section 111 definition को बताता है unless the context otherwise contracting state means any country place outside India in respect of which arrangement have been made by the central government with the government of such country through the treaty या otherwise identifying including establish of a proof that the property was derived from use in the commission of an offence. Proceeds of crime means हो गया any property derived derived obtained directly or indirectly by any person as a result of criminal activity including crime involving currency transfer, the value of any such property. Property means property and assets of every description, whether corporeal, incorporeal, immovable, tangible, intangible, and deeds and instrument, evidence title to an interest in such property or assets derived used in commission of an offence in include the property obtained through proceeds of crime. Tracing means tracing determining the nature, source, disposition, movement, title, ownership of property. Letter of request to complete. Letter of request. Letter of request to complete authority of for investigation in country place outside India. Section 112 Bnss. Letter of request for the country placed outside India, a country and authority for investigation in India. Section 113. 113. Assistance in securing transfer of person. Section 114. Assistance in relation to order of attachment for future of property. Section 150. Identifying unlawful acquiring property. Section 160. Seizure attachment property. Section 170. Management of property size for future under chapter. Section 180. Notice of for future property. For future property को नोटिस भेजना जो संपत्ति जब्त हुआ उसको नोटिस कैसे भेजेंगे. If as section 190, if as a result of inquiry, investigation and survey under section 160 the court has reason to believe that all any of such property are pursuits of crime, it may be served a notice upon such person hereinafter referred to as to the person affected, calling upon his with a period 30 days specified in the notice to identicate the source of income, earning assets out of which by means of which he is acquired such property, the evidence on which he relies, and other relevant information and particular to show cause why all any of such property as a case may be sued not be declared to be pursuit of crime and for future of the central government. For future of property in certain cases, section 120, fine in lieu of forfeitures, section 121, certain transfer to null and void, section 122, procedure in respect of letter of request, section 123, application of this chapter, section 124, and the central government may by notification in official gazette direct that the application of the chapter in relation to contracting state with which reciprocal arrangement have been made shall be subject to such conditions, exception, a qualification as such specified in the said notification. Security for keeping the peace and for good behavior. Security for keeping peace on conviction. Section 125. When when a court of session या court of a magistrate of the first class convict a person of any of the offence specified in subsection 2 of evading any such offence, and is of opinion that it is necessary to take security for from such person for keeping the peace. The court may at the time for passing sentence on such person order him execute a bond या bail bond of keeping the peace for such period not exceeding 3 years as it think fit. The offence referred in subsection 1 are any offence punishable under chapter 11 of भारतीय न्याय संहिता 2023 other than offence punishable under subsection 1 of section 193 and section 196 and section 197 thereof. Any offence which consists of including assault using criminal force of committing him mischief, any offence of criminal intimidation, any other offence which cause was intended or none to be likely to cause a breach of peace. It, if the conviction is set aside on appeal, otherwise the bond or bail bond so execute shall become void. An order under this section may also be made by an appellate court by a court when exercise its power of revision. Security for keeping peace in other cases. Section 126. Security for good behavior from person disseminating certain matter. Section 127. Security for good behavior for suspected person. Section 128. Security for good behavior for habitual offender. Section 129. When executive magistrate receive information that there is within his local jurisdiction as a person who is by habit a robber, housebreaker, thief, forger, is by habit a receiver of stolen property, knowing the same to have been stolen, habitually protect, harbors thieves, aids in the concealment, disposal of stolen property, habitually commit, attempts to commit, awaits the commission of the offence of kidnapping, abduction, extortion, cheating, mischief, or any offence punishable under Chapter 10 of the भारतीय न्याय संहिता 2023 under Section 178, Section 179, Section 180 and Section 181 of the Sanhita habitually commits, attempt to commit, awaits to commission, offence involving a breach of the peace, habitually commits, attempt to commit, awaits the commission, any offence under one or more of the following act, namely the Drugs and Cosmetic Act 1940, the Foreigners Act 1940, the Implies Provident Fund and Miscellaneous Provision Act 1952, the Essential Commodities Act 1955, the Protection of Civil Rights Act 1955, the Custom Act 1962, the Food Safety and Standard Act 2006. Any offence punishable under any other law providing of the prevention of hoarding and profiteering and adulteration of food, or drugs, of corruption is so this spirit and dangerous as a tender, his being at large without security hazardous to the community. See, such magistrate may, in the manner hereinafter provide, require such person to such magistrate so cause why should not be ordered to execute a bail bond for his good behavior for such period not exceeding 3 years as the magistrate think fit. Order to be made. Section 113 Bnss में बनाया जाता है. Procedure in respect of person present in court. Section 131 summon warrant in case person not so present. Section 132 copy of order of a company summon or warrant. Section 133. Every person warrant issue under Section 132 shall be accompanied by a copy of the order made under Section 130. Such copy shall be delivered by the officer serving and executing such summon warrant to the person served with or arrested under the same. Power the dispense with personal attendance. Section 134. Inquiry as to truth of information. Section 135. Order is given security. Section 136. Discharge of person informed against. Section 137. Commencement of period for which security is required. Section 138. Content of bond. Section 139. Power to reject security. Security को रिजेक्ट करने का पावर ए मजिस्ट्रेट में रिफ्यूज द एक्सेप्ट एंड security of offer may reject a security previously accepted by him his predecessors under this chapter on the ground that such security is an until person for the purpose of bail bond. Imprisonment in default of security. Section 141. Power to release person imprisoned for failing to give security. Section 142 Bnss. Security for unexpired period of bond. Section 143. When a person for whose appearance a summon a warrant has been issued under the proviso to subsection 3 of section 140 under subsection 10 of section 142 appears to brought before the magistrate या court, the magistrate या court shall cancel the bond या bail bond executed by such person and shall order such person to give for the unexpired portion of the term of such bond press security of same description as a original security. Every such order shall form purpose of section 139 142 both inclusive be deemed to be an order made under section 125 section 136 as the case may be. Chapter 10. Order for maintenance of wives, children and parents. Order for maintenance of wives, children and parents. सेक्शन 144 बीएनएसएस की धारा सेक्शन 144 में यह आदेश दिया जाता है इफ ऑर्डर पेरेंट्स माता पिता बच्चे और वाइफ का मेंटेनेंस के लिए इफ एनी पर्सन हैविंग सफिशिएंट मीन्स निग्लिकेट रिफ्यूज टू मेंटेन his wife unable to maintain herself, his legitimate child, whether married, not unable to maintain itself, his legitimate for illegitimate child, not being a married daughter who has attained majority, where such child is by reason of any physical, mental abnormality, injury, unable to maintain itself. His father, a mother unable to maintain himself, herself, a magistrate of the first class may, upon proof of such negligent a refusal, order such person to make a monthly allowance for the maintenance of his wife, such child, father, mother at such monthly rate as such magistrate think fit, to pay the same to such person as the magistrate may from time to time direct, provided that the magistrate may order the father of female child referred to in clause B to make such allowances until she attains he majority if the magistrate is satisfied that the husband of such female child, if married, is not possessed of sufficient means, provided further that the magistrate may, during the pendency of the proceeding regarding monthly allowance for maintenance under this subsection, order such person to make a monthly allowance of the interim maintenance of him, wife, such child, father, mother, and expenses of such proceeding which the magistrate consider reasonable, and to pay the same such and the pay the same to such person as the magistrate may for time to time direct, provided also that an application from the monthly allowance for the interim maintenance and expenses of proceeding under the second proviso shall as far as possible be disposed of within 60 days, 60 दिन 60 days 60 दिन from the date of service of notice the application of such person. For purpose this chapter, wife include a woman who has been divorced by has obtained a divorce from her husband and has not remarried. Any such allowances for the maintenance, interim maintenance, and expenses of proceeding shall be payable from the date of the order, if so ordered, from the date of the application of for maintenance, interim maintenance, and expenses of proceeding, as the case may be. If any person so order fails without the sufficient cause to comply with the order, any such magistrate may for every breach of the order issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole of any part of each month allowances for the maintenance, the interim maintenance and expenses of proceeding as the case may be remaining unpaid after execution of the warrant to imprisonment for a term which may extend to 1 month until payment if sooner made, provided no warrant shall be issued for recovery of any amount due under this section unless application be made the court to leave such amount within a period of 1 year for the date on which it become due, provided further that such person offer to maintain his wife on condition of her living with him and such she refuse to live with him, such magistrate may consider any ground of refusal stated by her and may make an order under this section. Notwithstanding such offer, if he is satisfied that there is no its just ground for so doing, no wife shall be entitled to receive an allowance for the maintenance or the interim maintenance and expenses of proceeding from her husband under this section if she is living in adultery if without any sufficient reason. She refused to live with her husband if they are living separately by mutual consent. On proof that any wife in whose favor an order has been made under this section is living in adultery, that without sufficient reason she refused to live with her husband, that they are living separately by mutual consent, the magistrate shall cancel the order. Procedure 145. सेक्शन 145 में प्रोसीजर को बताता है मेंटेनेंस का. प्रोसीडिंग अंडर सेक्शन 144 may be taken against any person in any district where he is where is his wife resided, where has last resided with wife, and cases be with the mother and legitimate child where the father, mother and resided. अल्ट्रेशन इन अलाउंसेस, अलाउंसेस में बदलाव करना, परिवर्तन करना, सेक्शन 146 बताता है. इन्फोर्समेंट ऑफ ऑर्डर ऑफ मेंटेनेंस, मेंटेनेंस के लिए आदेश को इन्फोर्समेंट कराना 147 बताता है. मेंटेनेंस चैप्टर 11 बताया मेंटेनेंस ऑफ पब्लिक ऑर्डर एंड ट्रैंक्विलिटी, दिस दिस dispersal या assembly by use of civil force, section 148. Use of armed force to disperse assembly, section 149. Power of certain armed force officer to Dispersed assembly, section 150. Protection against protection of act under section 148, 149 and 150. Section 151. No prosecution against any person, any act property be done under section 148, 149, 150. Public nuisance. Public nuisance conditional order for removal of nuisance. Section 152. Section 153. The order service of notification of order. Person to whom order is addressed to obey so cause. Section 154. Penalty for failure to comply with section 154 and 155. Procedure where existence of public right is denied. Section 156. Procedure where person against whom order is made under section 152 appears to the so cause. Section 157. Power of magistrate to direct local investigation examination of experts. Section 158. Power of magistrate to furnish written instruction. etc. Section 159. Procedure on order being made absolute a consequence of disobedience. Section 160. Bnss. Injunction pending inquiry. Section 161. Magistrate may prohibit repetition of continuance of public nuisance. सेक्शन 162. उसके बाद आता है पावर टू इशू ऑर्डर इन अर्जेंट केस ऑफ न्यूसेंस एप्रीहेंडेड डेंजर मैंने एप्रीहेंडेड डेंजर मीन्स आशंका खतरे की आशंका. सेक्शन 163. प्रोसीजर वेयर डिस्प्यूट कंसर्निंग लैंड वाटर इन लाइकली कॉज ब्रीच ऑफ पीस. सेक्शन 164. Power to attach subject of dispute and appoint receiver. Section 165. Dispute concerning right of use of land and water. Section 166. Local inquiry. Section 167. पुलिस टू प्रिवेंट ए कोजनेबल ऑफेंस. सेक्शन 168. पुलिस को पावर है कोजनेबल ऑफेंस को रोकने का. सेक्शन 168 में एवरी पुलिस ऑफिसर में interpose for the purpose of preventing and shall not be best of his ability prevent the commission of any cognizable offence. Information of design to commit cognizable offence. Section 169. Arrest to prevent commission of cognizable offence. Section 170. Prevention of injury to public property. Section 171. Person bound to conform to lawful direction of police. Section 172. Chapter 13. Information to police and the power investigate information in cognizable case. Section 173. Every information related to commission of cognizable offence, irrespective of the area where the offence is committed, may be given orally by electronic communication to an officer in charge of police station. If given orally, it shall be reduced to writing by him under his direction, and be read over to the informant, and every such information where given in writing, reduced to writing, aforesaid shall be signed by person giving. By electronic communication, it shall be taken on record by him on being signed with 3 days by the person giving it, and the substance therefore shall be entered in a book to be kept by such officer in such a form as the state government made rules prescribe in this behalf, provided if the information is given by the woman against whom offence under section 64, section 65, section 66, section 67, section 68, section 69 and section 70, section 71, section 74, section 75, section 76, section 77, section 78, section 79, section 124 of Bharatiya न्याय Sanhita, where it is alleged to have been committed attempt, the such information shall be recorded by woman police officer, any woman officer. Provide the further that in the event that the person against whom an offence under section 64, Section 65, Section 66, Section 67, Section 68, Section 69, Section 70, Section 71, Section 74, Section 75, Section 76, Section 77, Section 78, Section 79 and Section 124 भारतीय न्याय संहिता 2023. A copy of information recorded under subsection 1 shall be given forthwith free of informant the victim. Information as to non-cognitive case and investigation such cases. सेक्शन 174 में नॉन कॉग्निटिव केस में सेक्शन 174 जिक्र करता है. When information is given an officer in charge of police station of the commission within the limits of such station a non-cognitive offence, he shall enter a cause to be entered the subtract information in book to be kept by such officer in such form state government may by prescribe. We refer the informant the magistrate forward the daily diary report all such cases forthwithly to the magistrate. No police officer shall investigate a non-cognitive case without the order of a magistrate having power to try such cases, commit the case for trial. Police officer power to investigate cognitive case. Section 175. Procedure for investigation. Section 176. Report house submitted. Section 177. Power to hold investigation preliminary inquiry. Section 178. Police officer power to require attendance of witness. Section 179. Examination of witness by police. पुलिस द्वारा witness के examination. Section 180. Statement to police and use thereof. Section 181. No endorsement to be offered. Section 182. Recording on confession and statement. Section 183. Medical examination victim of rape. Section 184. Search by police officer. Section 185. When officer in charge of police station may require another to issue search warrant. 186. Procedure when investigation cannot be complete 24 hours. Section 187. Report of investigation by subordinate police officer. Section 188. Release of accused when evidence deficient. 189. Cases to be sent to magistrate when evidence is sufficient. Section 190. Complaint and witness not be required to accompany a company police officer not be subject to restraint. Section 191. Diary of proceeding investigation. Section 192. Report of police officer a completion of investigation. Section 193. Police to inquiry and report on suicide. Section 194. Power to summon person. Section 195. Inquiry by magistrate into cause of death. Section 196. Jurisdiction of the criminal court inquiries and trials. Ordinary place of inquiry and trial. Section 197. Place of inquiry or trial. 198. Offence tribal where done consequence insurance. Section 199. Place of trial where act in offence by reason of relation of other offences. Section 200. Place of trial in case of certain offences. Section 201. Offence committed by means of electronic communication letter etc. Section 202. Offence committed and journey of vehicle. Section 203. Place of trial for offence is travel together. Section 204. Power to order cases be tried different section division. Section 205. High Court to decide in case of doubt the district and inquiry and trial shall टेक प्लेस. सेक्शन 206. अगले वीडियो में हम आपको पावर टू इशू ऑफ समन वारंट फॉर ऑफेंस कमिटेड बियॉन्ड लोकल जुडिक्शन सेक्शन 207 के बारे में जिक्र करेंगे. आज का वीडियो यहीं पे वाइप आउट करें. डेट्स ऑल.